Good day to you all. My name's John Broome. I am the Deputy Chairman of the Contracts and Procurement SIG. We run a range of webinars or seminars, etc., events from the advanced to the beginners, if you like, and this is at that end. Sarah has previously given 2 webinars. They've been very well attended, very well received in terms of the feedback. So I'm very much looking forward to this one on basic contract law for project managers. What happens if it all goes wrong? So with that, I will hand over to Sarah.
Thank you very much, John. Hello again, everybody. And I'm thrilled to be back for our 3rd and final installment. It feels like the final frontier today. We're in webinar 3 of 3 of this wonderful series that I've been so delighted to be able to partner with APM to give to you. And thank you everybody who has attended the first 2 so far or has been able to listen to them after the event. This is our final one. So what to do when things go wrong or when the unexpected happens. So we're looking at projects where we've got some issues arising. Just to introduce the topics for today, we're going to look at what happens when performance breaks down. We have some issues in relation to one or more parties' performance in the contract. I'm going to look at 2 particular legal devices for issue management in contracts, and that's called frustration and force majeure, and all will become clear on those in a little while. Then we're going to look at dispute resolution and dispute avoidance, what we can do to get those issues sorted out and resolved satisfactorily. And then finally, I'm going to spend a few minutes just bringing everything together. So a short reminder for those of you who perhaps haven't been able to attend the other webinars or haven't yet been able to get some time and listen to the other 2. But the background to this series is this. The business that I run, Schütte Consulting Limited, our core belief is centered on the reality of using law in practice. I am a lawyer by background, as many of you listening will know, and I specialize in construction, engineering and infrastructure projects. But I have a real passion for making law work for industry, and that's also the strapline of our business. So we're all about using law in practice, applying law to your project as the project develops and as it realizes its benefits and delivers the outputs which are demanded of it. For me, project managers are central to the smooth running of a project. You have a whole heap of things to juggle, and you need to be multi-skilled in several areas. Parties to a project depend on you, project managers, to administer the project and to manage the contract, and also to some extent to give direction to the parties as to what they should be doing, the when, the how and the why. So why should project managers learn about contracts? Well, because there are 2 main risks when you don't learn about contracts. One is that the project is put at risk, or there is subpar delivery, where we want optimal delivery to deliver a project which is going to succeed. And the other main risk is that you yourself as a project manager and the organization that you work for may also be put at risk when you don't know much about contracts. So I'm a really strong advocate, again, many of you will know this from industry, to really get the basics on contracts, but also to recognize that there are limitations to this knowledge and to seek appropriate advice at the right time. So the background to the series is based on those core principles. The webinars that we've done to date are just coming up on the screen now. In webinar 1, we looked at how you build a contract, the very essence, the foundations of an arrangement, an agreement which constitutes a contract in law, and the essential features which you need to have in order to make that contract legally binding and enforceable in law. In webinar 2, we built on that knowledge from webinar 1, and we looked at the key terms of contracts, either when you're drafting a contract or when you're reviewing a proposed contract from your client or from one of the suppliers in the team. And now in this 3rd webinar, we're going to build on the first 2. We're going to look at the sort of challenges that might arise during delivery, performance issues, unforeseen risks, claims and disputes, and most importantly, to give you some tools for sorting them out so that you know what your options are to support that project. Now you might think, what have the project managers got to do with disputes between parties to the contract? I'm not a party to the contract between the employer or the client and the contractor or the consultant, or I'm not party to the subcontract between the contractor and its subcontractor. Well, I'd encourage you to see the centrality of your role again in the whole of the project, including the centrality in relation to resolving issues. And there's a number of reasons why I want you to hold that core principle close to your hearts. And that is that you retain day-to-day responsibility for driving project delivery. That is your core duty under the project contracts. You are, of course, also a natural conduit between the parties. As the project manager, you float between all the parties to the contract, and you should have good relations with all of them, and you should be relatively familiar, perhaps not in detail, but relatively familiar with the comings and goings of the project, with what's happening on site, and with relationships in general. So that's a really important part of being a project manager as well. You are also the custodian of records, the keeper and the maintainer of the project record. So you may be required to disclose documents to help assist in the resolution of issues which arise. And so you must have those to hand. Project managers also have powers. You're empowered to make decisions which bind the parties. The most relevant power and the most obvious power that you have is that you make an assessment as to time and money which is due, sums which are due, or contra charges which may lawfully be levied on the project. And then finally, your professional services which you are delivering to the project revolve around the project itself. And so any issues which arise in relation to the project, the baby which is being nurtured through to completion, then your professional services link in with that as well. So you most definitely have a central role to play in relation to resolving issues on the project. So, as I said here, let's get knowledgeable about what to do when things don't go as planned. Let's look first at what happens when we have a breakdown in performance. So by breakdown in performance, I mean that we have issues on the project, such as late delivery, failure to meet targets, maybe there's issues about the quality of the workmanship that's been done, or there's been some element of poor design that has to be redone, perhaps calculations were off, something along those lines. So we're talking about contractual obligations that belong to one party or another, which they are not fulfilling. Why does that happen? Well, for a whole host of reasons. Most obviously, lack of resource on the project or lack of expertise on the project. A failure to understand the key delivery outputs. Perhaps there are issues between the party and its suppliers. Perhaps there are problems with poor planning, coordination, or procurement lead-ins. There might also be internally to that party poor internal communications, poor project management on their behalf as an internal team, and thus it's affecting their output. There may also be cash flow issues as to why performance is not as required or as optimal, what the contract asks it to do. And I put finally a question as to this one, underpricing. That can also be and have an impact on the quality of delivery of contractual obligations. So lots and lots of reasons why issues arise and why performance is not as good as expected or not as good as what the contract requires it to be. And when performance is not as the contract requires it to be, that can be what we call a breach of contract. Now, what type of breach of contract it is and whether it can be a breach depends on the type of term which the party has failed to comply with, and also on the extent of what the failure actually is in law. I've put in brackets there webinar 2 because we looked a lot in webinar 2 on the different types of contract terms and how serious those contract terms are for performance. So if you haven't yet listened to webinar 2, do cross-reference at that point back to webinar 2. Now, if we do have a breach of contract, then the law may entitle that other party to a remedy. Now, there are lots and lots of different remedies in law. The most obvious one, which you may know about, are compensation, so financial recompense for having been the victim of a breach of contract. Okay, there may also be a remedy of termination in very serious circumstances of breach. And the law will work out what type of term it is, the extent of the failure of compliance, and then the remedy will follow. So there are no terribly hard and fast rules about that. It will all depend on the circumstances of what has happened and the context in which what has happened has happened. Now, in addition to the underlying law, the English jurisdiction, entitlements, the contract itself may also grant remedies. Now, they may be additional to the underlying law remedies, or they may be alternative to them. And the drafting of the clauses will tell you which one you have. So some of the ones I've popped down on the screen for you to think about are that there may be remedies for one party to withhold payment from another party or to set off some costs. There may be a remedy that no bonus is payable in certain circumstances. One party may become entitled to use retention money, which is held for a particular purpose. And those remedies may alter what is the otherwise underlying legal position. In addition, the remedy which is on offer may be time dependent. For example, the remedy of liquidated and ascertained damages, which you may not think of as a remedy, but it is in fact a remedy under a contract for failure to complete by the date for completion or by the practical completion date. The remedy of LADs or delay damages is time dependent. So you can't get that remedy until such time as the date for practical completion has gone by. Similarly, there may be defects which are linked to the defects period. For example, the use of retention money and the purposes to which that money may be put. So this is definitely an area in which it would be good to get legal and probably also technical advice, because you need legal advice on the type of the term and the extent of the failure, and you will also want to take technical advice from an appropriate person as to the factual matrix of the failure. So what has that party actually done? What should they have done? And what does that mean in technical terms? Do be aware, this is a really strong cautionary note, that if you terminate a contract and you are wrong about it, it's the general principle of law, then you can actually end up being the wrongdoer. So the wrongful breach which you are trying to terminate for is actually not a wrongful breach. That puts you in the position of becoming the wrongdoer in law. So you've terminated for a reason which is not a good reason, and the law won't support that. What that does is to flip then the rights and remedies around so that the other party could actually terminate you. So if you're listening at home, just put a big star against that one to remember to be really careful before you attempt to terminate a contract. Now let's look a bit more at not terminating contracts, but trying to get performance back on par. So how can we avoid issues in relation to performance? Well, a couple of the things which we talked about in previous webinars actually can minimize those problems from arising at all. First one is to really get sure that you're clear before the contract is formed. Remember in webinar 1, we were asking a lot of why questions. In addition to getting clarity before forming the contract, use those contract tools once you're in contract, because there's lots and lots of contract tools which are available in different forms of contracts some options are up there on the screen as well. The use of regular progress meetings to talk about issues which are arising or which might be on the horizon. The concept of early warning notices in the NEC contract and in the PPC 2000 contract, and to some extent in JCT contracts as well. And then in all contracts across the spectrum of project management and projects, there will be some form of change control process. So the way in which the original contract outputs are changed in some way. They're either reduced or they're extended or they're added to in some way. So try and minimize those problems from the outset. This is a great way in which project managers can add some value, actually. Then, once you are in that position, trying to get the project back on track, disagreements are hugely distracting to projects and extremely draining. I think at this point, project managers can really add value to their role and be that central cog in the project by being the key partner to communication, to the planning function, to securing commitment to performance, including things such as rectification of issues and defects, and also then the execution, the implementation of what needs to be done. So the project manager can play a really central role at that point. In terms of controlling problems, one very good reason to seek legal advice, not least because it will help your insurance position, is to obtain the entitlement of legal privilege. And that is a very special legal mechanism which is only available to solicitors and barristers. And it is a way in which you can start to keep some communications private from being disclosed to the court when they would otherwise have to be disclosed later on. So do bear that in mind as actually a very good strategic way to control problems. Another practical thing you will want to do in terms of problem control is to make sure you speak to the insurers. Depending on which insurance product may be available to cover the issue at hand, you need to speak to insurers in order to get their agreement in principle that they will cover off any claim which might follow. That's pretty complicated, and you'll definitely want to get some support from the brokers and possibly also from the lawyers. I do lots of work in relation to insurance claims and professional indemnity claims in particular, and it's a really good way in which you can have a good group of specialists all doing their separate thing but all working together to try to stem and control a problem which has arisen. In addition, of course, there will be internal procedures. There might be project-specific procedures, and there will also be internal procedures for your organisation in terms of reporting internally. Do remember that disclosure point I mentioned on privilege, and also on communications, whether they go external in public relations terms, or whether there are issues around confidentiality. So lots and lots of things to think about in order to try to minimize, first of all, performance issues from arising, and then some tips to try to get projects back on track and avoid those awful distractions of disagreements and relationship breakdown. So controlling problems is right at the heart of what project managers are in a perfect position to try to do. Now, what happens when you do get insurmountable problems? Well, you do get those from time to time, despite your best efforts. Insurmountable problems, of course, by their very nature, will usually end up in dispute resolution of some sort. At this point, I do have to say again, you must take legal advice on those, and also remember to follow whatever the contract procedure is in order to get the dispute resolved. Project managers will be part of dispute resolution procedures between whichever parties cannot resolve that problem between themselves. Do be aware that if the contract is not clear as to what the dispute resolution procedure is, then the law will automatically designate the courts. You'll remember from webinars 1 and 2, we talked about different terms, and we talked about what an implied term is. And this is an instance of an implied term. Also think about whether an industry-specific tribunal or procedure might apply. I know that there are a lot of people listening in who are in the construction and engineering industry, like I am, and of course you'll be aware of construction adjudication as a statutory right, which no contract, despite its best efforts, no contract can override. So you've always got that entitlement under the Housing Grants Act as amended to refer a dispute to construction adjudication. And there are other industries which offer projects as well, which will have their own tribunals and procedures to go through. One final remedy which may be available is injunction for specific performance. Now, injunction for specific performance is a really specialized area. It involves going to court on an application. Is very expensive, very intense. You're basically seeking an order. An injunction is an order, and the specific performance being sought is whatever is stated in the application that you're asking the court to enforce the party and force them to carry out. Okay, so it's not a remedy which is taken lightly, but I want to make you aware that it is a remedy which is available, and it may be, in relatively rare circumstances, appropriate to make an application for an injunction. One tip in relation to dispute resolution, which I was thinking about the other day in relation to a couple of cases I have on at the moment, is to, and this is again another area where project managers can really add value, and that is your centrality to the project as a whole means that you're in a good position to work out and analyse and assess all the other contracts which are related to that project. So are there any other contracts which are affected by whatever is the issue arising under a particular contract in some area? Is a subcontract affected, for example, or maybe a collateral warranty? Okay, you need to be ready to be able to talk to the client and the parties about what their options are in those circumstances. It may be, for example, that a beneficiary in a collateral warranty has some step-in rights. So it has some contractual rights to step into a particular contract and to direct what the parties should be doing, including taking over the position of one of the parties which is in dispute. Again, another area where you can have a think about the bigger picture and think about the project as a whole. And we'll have another look at some of these issues later on. Let's turn now to look at those two legal devices I mentioned earlier, frustration and force majeure. Now, both of them are examples of typical boilerplate clauses. We talked about boilerplate clauses in our previous webinars. However, they can sting, so do be careful with these clauses. They read very easily, they look very familiar, but they may not be exactly as the underlying law will otherwise say. So this is what the underlying law position is in relation to both of those devices. Frustration is an unforeseen event which happens that renders it impossible or illegal to deliver the contract. Or it's an event which results in a significant change to a party's purpose for entering into the contract. And it's a pretty complicated device, but we're talking about unforeseen events that either mean that you can't deliver the contract because it's impossible to do it or it's become illegal to do it, or the purpose of entering into the contract has changed so significantly that it is said to be a different type of a contract. So I've got a few examples here which you might find useful to refer to for future reference. So one example of impossibility is that you have subsidence occurring on the site, which destroys the access road and nobody can reach the site. Okay, so it's impossible to deliver that contract. Here's an example of illegality. a country bans the import of certain goods, and you, as the exporter, cannot export them. Okay, so that's an example of a contract which has now been rendered illegal. Okay, you can't do it because the goods have been banned. And finally, here's an example of the significant change. It's a little bit more complicated. An organisation with charitable status has that status withdrawn. And that means that the organisation can no longer afford the lease of a building which it had designated to subsidise for key workers. So in this example, the party, the charitable organisation, entered into a contract for the lease of a building, and the purpose of that contract was to house key workers in it. When charitable status is withdrawn, the purpose of the contract has changed to such a significant degree that the party can no longer fulfill it. So that's frustration. So unforeseen events that are happening. Force majeure is also about unforeseen events. Force majeure you may be more familiar with in the general sense because it is a phrase that we use in ordinary parlance. Force majeure is all about unforeseen circumstances which arise, which prevent performance. And those unforeseen circumstances are usually of the major catastrophe variety. So we're talking about environmental disasters, war, strikes, commotions, all that sort of thing. You'll see some quite interesting, it's probably in some ways the most interesting and exciting wording that you can go to when you're reading a contract, because it has such emotive and impressionable imagery behind it. You know exactly what it means. As I say, it's usually pretty obvious what they are, but they can be fairly nuanced. Now, I have a couple of projects out in Southeast Asia, and they have some really interesting wording on force majeure. Because of the location of the project, they have amended some of the words to cater for the types of commotions and disasters that tend to happen out where these projects are. So do check. In the UK, fairly straightforward. The examples which are given are more or less the same each time. But if you're working abroad and you're looking at where your project is, then do take care with force majeure, because it might be a little bit different from what you're used to reading. Now, what happens if a frustration event or a force majeure event occurs? Well, that's definitely going to be planning for the unexpected, isn't it? And what will happen is that the law will help you out. The law will actually end the contract automatically and allow the parties to walk away from their obligations and their rights under the contract. Again, that's one of those implied terms that we were talking about in previous webinars. The consequence of the end of the contract is that there are no penalties, there's no recovery for anybody to get any loss. In other words, law will treat those risk events as a neutral. Okay, so nobody wins, nobody loses. However, as with many other things, the law might give the underlying position through implied terms, but the contract might say something slightly different. So let's have a look at what the contract might say. That has to be your starting point, of course, because if your contract says different than what the underlying legal position is, then the contract will prevail. Now, that might be quite annoying at the time, because you might say, well, you know, force majeure is usually neutral, but hold on, I've got all these things that I have to deal with on my side, and the risks have all been allocated to me. That, I'm afraid, is going to be tough, unless the law will help you out further by saying that that particular term, which is really annoying to you, says that it is unfair and is classed as an unfair term. Now, we're not going to have time to look at unfair terms, but you know, if you want that, do drop me a note or put it on your feedback forms or whatever. Unfair terms is a specific piece of legislation and the court has some tests to apply in order to decide whether a term is unfair or not. If that term is unfair, then the court will strike it through and it will be knocked out. So be aware that that might happen in relation to frustration of force majeure. However, the reality of life and projects, especially in the UK, is that these type of events seldom occur. However, there is always a chance, and your risk management and your due diligence will say to you, please do those exercises before you agree the particular terms. So when you're reviewing the contract, when you're drafting the contract, don't just pop it in as an ordinary boilerplate that you don't think about. Going back to webinar 2 again, actually think about, before you agree the term, is it okay that we have this list of events in here as force majeure events or frustration events? Okay. Now, if you believe an event has occurred, again, you're going to need to take legal advice, because you don't know as a matter of fact if the law will agree with you as to that matter. Again, get the backup and speak to the insurers through the brokers or directly. And also, of course, if we're talking about physical projects, then take some technical advice to make sure that, for example, the site is safe, or the IT prototype project has been closed up securely. Okay, because when these events happen, it's very easy for the parties just to walk away, but there's a little bit of housekeeping that needs to be done in order to make sure that everybody is in agreement that we have one of these events, and that everything can be closed down sensibly and smoothly. So aside of these particular devices which will bring those contracts to end, and aside of breakdowns in performance, we're going to look now at dispute resolution. Big topic. Specific workshops available on dispute resolution and dispute avoidance too, because that is the cool and trendy thing now, is to be talking about dispute avoidance. And dispute avoidance is in fact the cool and trendy thing to do. So let's have a look at what we do to resolve disputes that might arise. Your starting point is this. The law will imply what the governing law is if you don't have a specific term in a contract. Okay? And the governing law will be the law of the jurisdiction, the country in which the contract is being performed. So in the UK, you may or may not know that we actually have 3 different jurisdictions. We have the courts of England and Wales, the courts of Scotland, and the courts of Northern Ireland. And they all operate fairly similarly, but there are differences between them. And you may or may not want to go to one or the other, depending on where you're, depending on what kind of dispute you have. There are a few nuances between them. How to avoid that uncertainty? Well, get a specific term in your contract. Like we talked about before, agree it pre-contract as a boilerplate term with reference to the location of the project and possibly also the registered office of the parties to the project. So where is a good common jurisdiction, which would be a sensible place for us to resolve disputes if we can't do them ourselves. If you don't manage to agree the governing law clause before you enter into the contract, you can agree it post-contract, or you can even agree it ad hoc at the time of the dispute, although I have to say I wouldn't recommend it. Again, you might be looking at what the location to the parties is. Where is the project being delivered? Okay, now the difficulty with agreeing things post-contract is that, frankly, you're already in a dispute with somebody, and therefore, why on earth should they want to come and collaborate with you about agreeing the point of jurisdiction? It's a point which can be taken as a strategic point or a commercial negotiation point. So I very strongly recommend to make sure that you don't get into this position. But if you do, then there are a couple of things that you can do. You can have a look at what the location is, and you can have a look at what the procedures available are. Okay. Now, post-contract, you can also agree different procedures. Okay. If actually it turns out that the issue in question is not suitable for the procedures or for the tribunals which have been suggested pre-contract, then you can do those things ad hoc. And a really good example of that is mediation. You can't force parties to mediate. You can suggest it in a contract, but it is always optional. Now, there are consequences, and I don't want to go off on a tangent this afternoon talking about mediation and the consequences of not agreeing to a mediation procedure. But do be aware that it is something which can be agreed ad hoc, and it is something which can be extremely effective for resolving disputes, whether or not it's written into the contract from the off. So avoiding uncertainty through agreeing your jurisdiction early. And that is about knowing what your strengths are. Let's look at the options for what, how disputes might be resolved. Again, your starting point is always going to be the contract. So here's some common options which you may well have come across. Tiered negotiation. So negotiation of different sorts, maybe at project level, followed by senior representatives level, something like that. That's very commonly seen nowadays. And in fact, it's worked its way into the new NEC 4 contract. Okay, they're loving senior representatives there now. Expert determination. That's really useful for technical issues that don't need a lawyer to resolve them, but need actually a technical person to look at the intrinsic difficulties between the parties. We've got also dispute avoidance boards and dispute resolution boards. Now, those can be standing, so those can be written into the contract, and they are there permanently during the course of the project. And you can also have boards which are ad hoc, so boards which are convened solely for the purpose of attempting to resolve and avoid disputes. Mediation, as I mentioned, that is consensual in the UK. Note it is not consensual in other places. If anybody's interested in how on earth you manage to get mediation as a philosophical principle into a forced procedure, might like to go onto my website and search for the word Italy. I'll leave that one with you if anybody's interested in that one. Court, of course, and arbitration. Now, arbitration is a separate, private dispute resolution procedure. It can be domestic, i.e. For a project and for parties in one jurisdiction, such as the UK, or it can be international arbitration, and there are locations set up specifically to deal with location-neutral arbitration in the international project sense. So lots of different ways in which your contract will tell you what are the procedures for resolving disputes. Again, just be clear whether you have a statutory tribunal which could disapply any of the neat timetable which you've drawn out from that bullet point list above. Okay, and again, in the UK, we've got 3 sets of regulations for adjudication, one for England and Wales, one for Scotland, and one for Northern Ireland. So don't assume that construction adjudication is the same across the board. In terms of international projects, a good tip is to get knowledgeable about what the local laws and procedures are. Some of the work that I've done in various places around the globe has required some quite interesting actions to be taken, including lodging costs at court via a bond and also via cash. Okay, so some jurisdictions around the world want you to put money up front in case of compensation award. In another part of Southeast Asia where I've been working recently, there is in their local arbitration procedure a limitation as to what costs can be recovered, and that is proportionate to how much award is being made. So there's some quite nuanced steps and processes to international project procedures. So get knowledgeable about whichever jurisdiction you're in, and of course take local legal advice on how those procedures are applied. Finally, and again, I mention this because it's really important, remember what the impact of insurance could be. You want to make sure that an issue which needs to be insured has cover. Okay, cover is the insurers agreeing in principle to pay out on the claim. And also be aware that some insurers like to direct what the parties are going to do in terms of the dispute resolution procedure. So the insurers need to be fully involved from the off. Lots of options then for dispute resolution and lots of things to take into account. And for project managers, I think this is definitely an area where you can give some stability to the project, depending, of course, on the severity of the issue at stake. But I think for project managers, knowing what your options are, knowing what the parties' options are under any particular contract is going to be a strength, and it should be a strength to the project, and it should be a strength to all of the parties to the project when you have those disputes. Now, of course, we're talking about relatively small numbers of claims which can't be resolved. Statistically, over 90% of claims and issues which arise on contracts are negotiated to a sensible commercial settlement. And that's really great news because it preserves relationships. There is, to some extent, a necessity. If you're in the middle of the project, you've got to sort it out. You've got to have an ongoing relationship to complete the project. There may also be market reasons. There may be just a small group of suppliers, for example. If you're in a partnering contract, of course, you have no choice but to try to, in some very difficult scenarios, come to sensible settlement. And I wanted to also add there, this is one of my passions, which many of you will know about, is that the project can benefit. And the project should be looked at as an entity in itself. Okay, it is good news for the project that issues are settled sensibly. Some other reasons for individuals is the human element of why we want to settle claims. And that is the costs involved, the emotion and the distraction and the draining that we have when we are embroiled in disputes. For project managers, it's really important that you understand what the parties' options are. And you also must be prepared to participate in the dispute resolution process. Because again, remember, you're the record keeper, you've been administering the parties' relationships. You may have also made assessments or decisions which have been binding on the parties, and one of those is what they're now complaining about. So you are very much at the center and at the heart of the project itself. So being prepared to participate in the dispute resolution procedure is something which you need to take advice about. Okay, don't forget about the project for sure, because the law will ask you to continue to perform your project manager's duties while the dispute is ongoing. You may be aware that adjudication decisions are binding on the parties, and they must be performed unless and until some other set of proceedings or court decision or arbitration decision says otherwise. Okay, and this is similar. So don't forget that you are managing or administering the project, notwithstanding the fact that the parties are in dispute. One very important NB to all of this, to look after yourselves as project managers, because if there are issues about your performance, then you must involve your organisation's professional indemnity insurers to make sure that you have any cover should there be any pursued claim against you as the project manager for something which you have done or not done. It's not terribly palatable to think about it, and it's not a nice place to be. But as someone who has had to direct and manage PI claims, I have every sympathy with people as individuals who are caught up in that. And I also have sympathy with the fact that the organisation needs to protect itself and make sure it's got the cover that it needs should any claim be pursued against it. So do not hide away from any of that, and do please involve a friendly and sympathetic lawyer and your insurance broker who can help out with that. I'm going to start bringing it all together now while you think about. So, project managers, when things go wrong or the unexpected happens, the parties to the project will panic, and that's only natural. But project managers, you shouldn't panic, because I believe that this is an area where you guys and girls can add huge extra value to projects. You can be that source of stability. I said here that you need to be robust to direct the project. I've talked before about the benefits of excellent project managers and what it means in a competitive environment to be an excellent project manager. And this is one of the ways in which you can show your clients and the project teams that you are an excellent project manager. you need to be robust in directing what the project is going to do from here on in. You can only do that if you are knowledgeable about the contracts, about those key performance obligations and what the rights and remedies are in any situation. That doesn't mean being an expert in contracts or a specialist of any sort. It just means having spent some time reading it and working out who needs to do what when and what the options are when things go wrong. Now, if you're able to participate and help to settle issues between the parties, you might be a useful person to remind the parties that they need to put those agreed terms down into writing. It's no good having resolved an issue to then not document it. It's a very important part of record keeping, and if there is any further dispute which arises, it will be a supplemental part of the original contract. So you're going to need to remind them to get their lawyers on the case to get a supplemental deed issued or a supplemental agreement to the original contract. Some sort of contract variation, not a variation to the project deliverables, but a variation to contract terms, and that is only something which your lawyer will be able to draft. So do remind them. This is a useful thing that project managers can do on the housekeeping and the settlement stage. Everybody tends to think, oh, thank goodness, we've sorted that out, let's move on and off we go. But actually, it's a very important piece of housekeeping to be done. As I mentioned before, there may be other contracts which are affected by issues which are arising under the contract. And this again is an area where project managers can step in and add value to contracts. For example, if you have a bank facility in a contract which is dependent upon getting sign-off from a monitoring agent, then in order for that bank facility to be drawn down on, we need that monitoring agent's sign-off. Now, if there have been issues about defects and workmanship, remediation, things like that, you will need to organise for that agent to come back on site, to come and see what's been done, and then to enable that block in the process for the drawdown to be moved away. Step-in rights, I mentioned earlier. Collateral warranties are really, really important. Short but lethal collateral warranties can be. There will be times when the step-in rights enable the beneficiary of a collateral warranty to step into the shoes of one of the other parties. Okay, the typical events which trigger those rights for the beneficiary upon non-payment of sums due, subject to some process for giving time to pay the sums due, okay, in the usual way. But also step-in rights which arise in relation to one party's insolvency. Okay, so being aware of whether there are and to the extent how many collateral warranties there are on a project will also be a useful thing for project managers to ask about. Generally speaking, I'm suggesting that you be active, you be helpful on your projects, and in times of disputes and crises, you can actually be the pillar of common sense on the project, and I commend you all to be that pillar. I know I certainly rely on project managers in projects when I have disputes and claims to deal with. The project manager is usually the person I will go to first for all of the reasons that we've just talked about in this past 50 minutes or so. The pillar of common sense, the central cog to the wheel of the project, the record keeper, so some practical and some also very philosophical reasons why I will come to you and say, this project needs your help, I need your help, and together we're going to try to resolve these issues. So let's summarize what this webinar has been all about. Whistle-stop tour of issues, unexpected crises, challenges, and all sorts of things which can happen to throw your project out. Issues arise on every project, whether projects are small or big or any which way size. For me, what's important and what matters is that project managers deal with those issues, firstly, of course, in accordance with the law, Secondly, in accordance with the contract. And thirdly, they're giving the right level of service to that project as well. It's an opportunity for project managers to shine in difficult times. And as a project manager, as mentioned, you're likely to be right at the centre of claims and disputes, and you have a great opportunity to add value to your clients. Just remember, however, the law can be very strict in this area. We talked about the strict rules that apply to legal devices of frustration and force majeure, for example, which is very simple, but is actually incredibly complicated. So do take advice on what the options are and work out what the strengths and weaknesses are as well. It would be extremely helpful to anybody without any prior knowledge of the project. It just remains for me to thank you all for joining us, and I'm going to award a remote gold star to everybody who has managed to attend all 3 webinars. First one goes to me, I guess, because I've prepared and delivered them. To John, to everybody at APM, huge thanks. I hope it's been enjoyable for all of you. You've taken 3 hours out of your days to take time to listen and to join us. I would be thrilled if you would please give your feedback and do get in touch if there's anything specific you want help on. And finally, any questions. I'll hand over to John to collate and feedback if there are any questions that anybody wants asking.
They are suddenly at the end coming in thick and fast. So so the one which I wanted to do was from Kerry. Does the concept of frustration of a contract apply to a contract governed by Scots law, or is this an English law concept? Can only the English get frustrated?
Well, there's lots of reasons for the English to get frustrated right now, and fewer reasons for the Scots to get frustrated. No, in all seriousness, Scotland does have frustration as a concept. I'm not a Scots lawyer, so I couldn't comment on the nuances as to how frustration applies, but it is a concept of law which has been in all the UK jurisdictions for hundreds, if not 1,000 or so years, and it's in fact a concept which we've exported to other jurisdictions around the world. So I can safely say that the Scots and the Northern Irish, the Welsh, and plenty of other jurisdictions get as frustrated as the English do.
Okay. Related to our next question from Samuel, your answer: does frustration and force majeure apply to all global markets, or is this specific to the UK? For example, USA, Canada, and Mexico also apply. And
yeah.
Samuel added, thanks, very useful series.
Oh, well, thank you very much. I appreciate the comment. In essence, yes, again, all those jurisdictions have these concepts. They will have their own versions of these concepts such that they fit neatly within their own jurisdictions. But the USA has taken a large part of its law from English law, of course. Canada also. Mexico I'm less sure of, but if anybody wants to send me there, I'm happy to go and check it out.
Okay, we've got a question from Daniel. Can you briefly describe termination? The idea that termination can be flipped based on who is the wrongdoer suggests it's not as simple as the contract coming to an end and the outcome depends on who is the wrongdoer. So comment on that.
Yeah, of course. Termination is a whole webinar on its own. So if people are interested in termination, we can maybe look at that separately. In relation to the specific point that Daniel has raised and the point that I made in the webinar was really a cautionary point to be careful before you think about issuing the notice of termination. If you issue a notice of termination and you're wrong to have done that, then you become the wrongdoer. And at that point, then the right to terminate could flip to the other person. A piece of cautionary advice as much as anything. Be really careful about your reasons for terminating. If there is a general right to terminate, then you have no problem, provided you follow the process, the notice is in the right form, you've complied with timescales, etc. But if you're relying on a breach of contract to terminate and you're saying, right, I'm going to terminate this contract because you've breached it, that's your danger territory. That is when you're going to need to speak to someone and talk about the sort of things which have been happening such that you now believe there is a breach of contract, and you've got to be damn sure about those. I've had one or two which have been right on the cusp of being one side or the other, and it's a tricky place to be. It's a tricky place for contract lawyers, let alone for project professionals.
Okay, time for a couple more. What are the latest preferences around 8ER types, so alternative dispute resolution types? Is arbitration going out of fashion in favour of mediation? That was from Philip.
Well, arbitration and mediation are totally different animals. Arbitration is really on a par with the court, because both of those tribunals, you are asking a neutral expert third party to make a decision about a dispute, because you and the other party can't do it yourselves. So arbitration, yes, it has gone out of fashion in recent years. There is a short version of arbitration which is gaining in popularity, but courts are overwhelmingly the preferred place for dispute resolution, save for international projects where international arbitration in that location neutral venue is preferred. In terms of mediation, that's definitely gained in popularity. It's also been pushed a lot by the courts of England and Wales, and also Scotland and Northern Ireland as well, and in lots of other jurisdictions around the world, because it is seen as philosophically more palatable. The mediator is brought in as a facilitator, not as a decision maker. The parties are in control of the project, and to some extent it is said and seen, and it is true, to be cheaper than legal proceedings. Legal proceedings will almost inevitably destroy a relationship or harm it significantly. And mediation is seen as a way in which parties who want to preserve their relationships, or perhaps they need to, as I mentioned in the webinar, there might be necessity to negotiated settlement and to the employing of a third party to help you, then mediation is a good place to be. It really depends where you are philosophically on that spectrum of relationship with the other party. But I would say definitely consider it carefully.
Okay, unfortunately, we haven't got time for any more questions. Lots of people have written in and said, thank you very much, and very useful series. So I would add to that, Sarah, before I just flag up a few extra things from the upcoming from the SIG. So thank you very, very much, Sarah. I know you put a lot of effort into this to make it a crisp, short, succinct presentations which were to the point.
And
okay.
There's a whole heap of traditional and modern ways to get in contact as well. So whatever is convenient to listeners.
So before I go, just remind people that parts 1 and parts 2 are already up. So with that, first of all, thank you very much for listening. An extra thank you to Sarah for giving the presentations. Thank you very much.
Absolute pleasure. It's been a lot of fun.